Hi, everyone. Thank you so much for joining us for this much awaited webinar. We've been wanting to have this conversation, and I think it's one timely, but also a very unexplored conversation, particularly in the climate space. Today, I will be wearing two hats in that one, I work in the climate space, but also I happen to be a lawyer. So I guess that's why I was asked to moderate. I have the best of both worlds in terms of just the synergy and where the climate conversation meets the legal conversation as well, and just legal developments holistically. My name is Karabo Mokgonyana. I work for PowerShift Africa. I co-lead the energy team, but primarily working on just climate and energy. And as mentioned, lawyer by profession. Also doing a lot of research as a PhD student, PhD candidate, primarily working on just law, energy, and the climate agenda in itself and where it sits. And I think this conversation is quite important because when we speak of, the climate realities, there's an element of accountability, an element of responsibility, element of institutional capacity and responsibility as well, that often is missing within this conversation. So often you either have a lot of measures, a lot of things that are adopted that are either not binding, that are not as impactful from an institutional and government perspective. And for the first time, with the ICJ decision, the International Court of Justice decision, there was a bit of a shift in how we're looking at the legal dimensions of this conversation. So just for those who don't have a bit of that background, there was a unanimous advisory opinion that was delivered July the 23rd in 2025 by the International Court of Justice, specifically looking at the obligations of states in the context of climate change. And that was quite historic and very important because often a lot of these cases and precedent would revolve around a specific thing. So it's either like mining community, mining rights, environmental and social assessments, and those kinds of things. For the first time, this conversation was had, one, at a very high international court, but also at a broader level, in that we're not talking about in the context of something that has happened or reacting to something specifically. And basically in this opinion, the court basically confirms that there are international law obligations of states, and states basically have international law obligations to advance climate action, and that there could be legal consequences arising from acts and omissions that cause significant harm to the climate system and other parts of the environment. While that is not binding, so I need to definitely clarify, it's not legally enforceable and binding because it's an advisory opinion, but it carries a lot of legal weight in that it shapes how the states view themselves in the context of who they are in enforcing climate change actions, but also in terms of responsibility, accountability, and just the relationship that the state has equally with just citizens holistically. So it's really shaped how institutions operate. It's changing how governments are viewing themselves in the bigger conversation on the climate. And we wanted something of that nature, to trigger the conversation on what does legal responsibility look like? What does accountability look like from a state obligation point of view? And the minute that conversation started, it triggers something. It triggers a lot more conversation on us having precedent, institutional accountability, but also ensuring that this is it presents some level of certainty and credibility to this conversation. Otherwise, we'll be going to, for example, your corpse for 30 more years trying to figure out, non-binding terms and those kinds of things. So it really makes and creates some level of legal certainty, which is something that is required within this climate space. So this webinar is, we're not just coming to have a conversation and just, provide information on the ICJ decision, but it's happening on the backing of a policy brief that was developed by PowerShift, basically called Implications of ICJ Advisory Opinion on the Climate Obligations of African States. So there was a lot of conversations that was had generally in terms of, small islands, LDCs, what the implications are of the specific advisory opinion. But I think the African continent was not really having a conversation on what this means for them, specifically because a lot of the historical polluters are sitting in a lot of the global north countries, but also African governments themselves have some level of responsibility in terms of, or accountability in terms of state obligations, because there's a lot of decisions that are happening. There's a lot of financing that's happening. There's a lot of investment in terms of adaptation, mitigation that's happening, but also there's a lot of decisions in mining, transition minerals, industrialization that have an impact on the environmental rights of communities and so forth. So having this conversation from an African perspective is what we wanted to do and create that relevance. But this is also timely because there is then currently there is a court decision, or there is a case at the Africa People and Human Rights Court, and it follows a very similar flow in that we're trying to determine the linkages between human rights and climate change violations and what that means. And again, now it's sitting on the continent. So how the linkages between these two cases, or how that case could influence the other one, we really just want to speak about legal obligations, state obligations, and what all of this means. The legalities of this conversation, heavily underexplored, and something that we definitely want to speak about. So we do firstly invite you to read the policy brief. We think there's a lot to get from it in terms of the essence of what we're trying to say. And we'll speak about some of those themes that we have picked up with, the panelists themselves, but also just engage a bit more on where the legal conversation sits in this bigger conversation of climate change. Because with time and the threat on climate change financing and so forth, a lot of things related to legal certainty are going to be very relevant to push a lot of the work to be done, or at least climate action from a state perspective. With that, I would like to invite my panelists to introduce themselves. I want to introduce you guys, but I would like to at least not hear myself speak the whole time. Would like to ask you guys to briefly introduce yourselves, and maybe just a quick one on your initial thoughts when you heard about the ICJ advisory opinion. Something really quick. Yes, I will start with you, Dr. Joyce.
Thank you very much. So let me start introducing myself. And even before that, I think I just want to thank PowerShift for organizing this meeting, this webinar. I think these are the kind of conversations we want to have. I'm very excited to be part of this discussion today. I would also like to thank everyone who's joining us this afternoon or wherever you are this morning to be part of this conversation. So I will start by just introducing myself. I'm Joyce Kimutai. I am a climate scientist with a particular sort of focus or expertise on attribution science, which is basically just a branch or a subfield of climate science that looks at the role and contribution of climate change, particularly anthropogenic climate change, so the human-induced climate change, on extreme weather and climate events in terms of their frequency and their intensity. So basically think of a flood, a drought, a heat wave. I do the science that tries to quantify to what extent is climate change increasing the frequency in which they happen, or the intensities in which they happen in the current climate. And we compare that with the climate of, or like the pre-industrial climate. So before we began industrial revolution, or before we actually humans started influencing the climate by emitting greenhouse gases. I am very excited to be here today. I contributed to Kenya's submission to the ICJ, or for the ICJ submission by Kenya. I also been coordinating a team. I mean, I know you you mentioned this, but I think it'd be nice to mention this again, that there's a process, there's an ongoing process at the African Court of People and Humans Rights to issue an advisory opinion on obligation of the African states on climate change. So the African court was petitioned by Pan-African Lawyers Union and other organizations to issue an advisory opinion. So, I mean, ICJ is sort of the international one, and then we have the regional one. So there was the American one, the European one. Now we have the African one. It's in process. So I coordinated a team of scientists, lawyers, and some economists to make sort of an independent submission to the court on science, on the intersection of science, law, and economics, to support the court in trying to understand what could be the obligations of African states. And I think something very important to say as well is that when we talk about obligation of African states, it's not just about what is their duty of care, what is their responsibility, but it's also about how do they position, where do they position themselves in the global space, in the global discussion, in the shared responsibility, in terms of how it can protect its citizens from the impacts of climate change. So I'll stop there for now, but I will come back with sort of more engaging maybe sentiments. Yeah.
Yeah. Thank you so much for that introduction, but also just that opening. I think that context was definitely necessary, and I like the interdisciplinary conversation we're about to have, because often when you have lawyers, you don't have the scientists in the room, or the scientists are having conversations on their own, the lawyers are having conversations on their own, the social scientists are having conversations on their own. And the more you get into these different spaces, you realize how it's so important for all these different people to be in the same room, because there's relevance in how they communicate the different nuances, and whether it's from a legal and from a legal perspective, whether it's from a scientific perspective, whether it's from a social science perspective, all of it is just quite relevant. So it's a pleasure to have you here. I will call on Abdoulaye Dia to do an introduction and just initial thoughts.
Thank you, Karabo. Hi to the other speakers, and hi to hi everyone. I'll start with thanking PowerShift for this opportunity, and this is really a very wonderful and also very strategic opportunity to discuss the ICJ advisory, its effects on Africa. And you're right, Karabo, having scientists with lawyers is something really, really wonderful. I wish we had also some communities on this conversation, but lawyers are also interpreters of communities, so I think we can also be their representative here. My name is Abdoulaye. I'm leading a really newborn non-profit organization on this field. I'm the founder and the president of Goshen, the Center of Gore on climate, environment, heritage, and human rights. So we are based in Senegal. I'm also a senior legal counsel. My daily work have been for more than 20 years working on business laws and things like that. I've been on the other side. I've been with oil and gas companies before joining the good side. This is what I think. and I'm one of the fellows. So I'm alumni of the African Climate Legal Fellowship Program, which have ended his first cohort, and which was a real good opportunity for 12 12 mid-career lawyers to jump in the field, coming from many other fields. So my work stands at the intersection today. My work stands at the intersection of law, climate justice, heritage, protection, and community action. And so through GOSEAN, we work with islands, coastal communities, starting from Gore. I don't know if you know Gore Island, or which is famous for the role it played on slavery and on colonialism in Africa, which is another story. But that's where we are based. So we are starting from Gore to connect climate resilience, environmental protection, human rights, cultural memory, and education. And for us, climate justice is not only about international negotiations, it's also about what happens in the daily lives of communities facing coastal erosions, biodiversity loss, source of livelihood, and the gradual loss of cultural and territorial anchor. And on first suit, I will be very brief. The ICJ advisory opinion is enable Africa and all the other countries to move from a narrative of vulnerability to a legal strategy of responsibility. This is the move which really have very big meaning for me. And so we are moving to reparation and public policy transformation by placing affected communities at the head of evidence and decision making and climate justice. When you analyze this, the ICJ advisory, the role they want, the place they give to communities in the evidence making, in bringing proofs and things like that, and which is backed by the science, is really something wonderful. And we are no longer on the perspective narrative of vulnerability. It brings it to the legal side, and now we are able to discuss about liabilities, about decision making, how we can influence the government, the states on this decision making in protection of communities and things like that. I'll stop there. We will have we'll be able to develop more, and this was my first. So thank you.
Thank you so much for that. That was really powerful. I think you basically took us and reminded us of why we do all of this stuff in essence. I think you had really said it well to say placing communities at the heart of, the evidence, moving away from the vulnerability framing and getting into things like legal certainty, reparations, public policy, decision making. And that's what, definitely this opinion is doing. But also just trying to make sure that whatever decisions or whatever frameworks, whatever institutional capacity or accountability we are pushing forward, community and people are really at the heart of it. Because, the impacts of climate change, all these things you speak about, the cultural parts, the migration, the territorial, all of that stuff, biodiversity, all of it impacts humans at the end of the day. And sometimes we can speak about these things in a very abstract manner where we forget that all the efforts and all the work come back to communities, come back to people, and come back to what does all of this, and even in the context of international laws and international frameworks, what does it mean for African people? What does it mean for our people? So definitely, and I would highly recommend people definitely to visit Gore Island. I have, and it's very, very much, very special visit, very important visit that I think all Africans should definitely do. I'm going to bring Mark. Please kindly introduce yourself and just your initial thoughts.
Thank you, Karabo. I mean, I'll join the other speakers in first extending congratulations to PowerShift Africa for this policy brief. I think I echo the sentiment that it's very timely and very necessary. I think it's a useful tool, and more of documents like this that are accessible and opportunities to discuss like this are what help translate what is a very expansive advisory opinion into tangible measures and steps that people can take at a very local level, because I think that's where the room for change is. There's so much that one can say about this advisory opinion, but I think what it does is very simply translates a simple idea that the state's obligations and the state obligations in the context of climate change are not discretionary, they're binding. The fact that there's a requirement that they be progressive and more ambitious, again, is not discretionary, it's binding. And finally, that there are implications for not meeting these obligations. So it's a really important thing. It seems very simple. The other thing, to be a bit legally technical, is this effort to try and constrict the scope of obligations to a couple of treaties under the UNFCCC. The court rejected that. And so what the policy brief highlights, which I think is also important, is that these obligations are also drawn from customary international law. So there are duties of due diligence, and they're stringent, again, not discretionary. There's a duty to prevent harm for transboundary air pollution, and there's no distinction, whether it's fumes or it's climate change, just because we can't see these greenhouse gases doesn't make a difference. And all of that collectively, I liked the way you put it, Dia, is it transforms African states and communities who suffer disproportionate impacts from victims. It gives them tools and shields to move in the right direction. I thought of one implication, which is practical, which cuts across several different aspects, that is legal, political, economic. I think climate implicates all of these. And I think the one thing that this does is to provide I think a really strong, powerful tool, because one of the questions now is how do African states position themselves? And one of the challenges has been that as these African states move to make stringent regulations to regulate fossil fuels, for example, they're either sued by investors, foreign investors, or there's a threat of being sued by these investors. But I think what this advisory opinion does is provide like a structural shield, because those changes that these African states are bold enough to take nationally now have an anchor in international law, and they can use that as a shield. And because it's not restricted just to a couple of treaties that have very loose sort of obligations, but also these customary aspects, it doesn't matter. Whether you have an existing bilateral engagement or not, you already have this tool. And I think that's a really great step, because it means there's a legal arsenal for African countries that want to position themselves progressively. It means there's a basis for different communities and groups that want to champion and stand behind their governments and support them. There's huge implications politically to renegotiate some of these bilateral treaties. And economically, of course, I think it just relieves some of the pressure that you'll be sued by these huge investors if you attempt to make more progressive positions in relation to fossil fuels. And I think that's something that's stood out personally for me. Thanks.
Thank you so much, Mark. And I think you bring a different layer that's quite important, in that you're not just telling us about the one-sided element of, yes, states do have the obligations, but also the leverage that African governments actually have, how this is not only presenting, responsibility and that they need to act on it, but there's also shielding that this advisory opinion presents to African governments, particularly in the position that they are in regarding, investments, some of the relationships that they have with investors. And yeah, that's important. And something I think a layer that's very important for governments to know, at least, because of the position from a bargaining power point of view. African governments do tend to think they don't have any sort of shielding, and they may have to just, continue with the terms of original agreements and so forth, and neglect some of the state obligations from a climate point of view. So that's definitely a really great angle. I will bring in Meshack, who happens to actually be the lead author of this policy brief, and maybe you could well, besides introducing yourself, tell us a little bit about, I guess, the thinking behind this policy brief, and yeah, just your initial thoughts. Yeah. Meshack, I can't hear you. Yeah. No, still can't hear you. I think maybe try and determine where your speaker is. Sometimes okay.
Thank you. Sorry, everyone. I was saying a big thank you to everyone who has made time to contribute to this very, very important discussion. And to just introduce myself, my name is Meshack Mboya. I'm the legal and advocacy advisor to PowerShift Africa. Worked on this policy brief, which is extremely important. And to just provide some context on it is, after the advisory opinion came out last year, a lot of the discussion, of course, on accountability, and just the recognition that there's an international now law obligation on states to protect the environment system and not cause any significant harm. But the discussion was not happening in Africa in terms of what do we think this means for African countries with their specific context within which they exist, and of course the overbearing reality that they are the least contributors to the crisis, yet they are the most vulnerable and are the ones facing the most direct impacts of the climate crisis. So it was extremely important to try and contribute to the discussion from an African perspective, and PowerShift as an African think tank. We thought this is an important aspect for us to contribute in. The other important aspect for it, and I think this is something that Mark has actually highlighted, is not just looking at the decision from a victim perspective for Africa, but also to say, oh, look, it is actually also giving you some space to regulate. You have some breathing space for you to say, we have a right to regulate emissions. We have a right to regulate the climate system. So we are also able to take action with respect to investors, to ensure that we are able actually to contribute in a way that is positive in regulating the climate system, including things to do with bilateral investment treaties and all that. So some form of reform in that area, which has taken long decades of discussions, but really no action in that area. The other important thing is that right to regulate also cuts twice in terms of both sides. It's a tool for the states to also actively manage the climate system by managing investments in their country. But also on the other side, it gives communities and the people in that country a tool for them to go to court and say, this country has a right, has a duty to protect the climate system. It has a right to regulate, yet it has done nothing. So now, because it has an international legal obligation to protect the system, it also means doing something, not just not doing something. And this will be important because also it will protect communities more and more as we go ahead. And I think another good example here is like the Lamu Call case, the Kenyan case that, was at last finally decided last year by the Environment and Land Court, in which, of course, the challenge was for the environmental impact assessment license. And I'm happy that Mark is here also acted on that case. But importantly, now it will be easier for those communities to also bring out human rights violation concerns. Like coal, there's a lot of concerns about it with air pollution as well, and air pollution related deaths. And I think Karabo, this is something maybe she'll be aware about in terms of just the numbers are crazy, like in South Africa, which is a huge coal producer. And, these are some of things that now can be brought to the fore, and now they've been recognized within the climate system. Yeah, and I'll stop there. Thank you so much for everyone who was joined.
Thank you so much for that, Meshack. And yeah, I mean, well done on the putting together this policy brief. I think it's really started an important conversation. And I think it's only the beginning of what we hope is going to be more fruitful conversations, not only in the context of what's happening at the Africa Court, but also even in domestic courts and what we hope will happen holistically. And maybe let me bring in Mark there. Yeah, I'm just going to jumble the questions and ask in terms of like, just from your experience, particularly in, public interest litigation, do you see this ICJ opinion influencing one, obviously not just the African Court on Human People's Rights, because we've spoken about that, but also domestic courts across Africa, because sometimes the impact at like ICJ or the Africa Court could be so distant from from or removed from people or from legal systems in country. How do you see just that ripple effect, or at least what we hope to see in terms of it trickling down into country level or even county level, or yeah?
I think that's a really good question, and I think my answer is yes. I think this opinion is most likely to be even more relevant for domestic litigation, even before we get to the level of the regional court level and the pending advisory opinion from the African Court or other decisions at different regional and sub-regional courts, for a couple of reasons. I think when you take a lot of these cases at a domestic level, you're often dealing with decision making, which involves regulators, so that's states. And so you're challenging the decision making, and most times the most predominant tool communities have for this is through environmental impact assessments. A lot of challenges focus on the procedural elements, even when you're dealing with fossil fuel projects. What I think this case does is, the opinion does is just broaden the scope for arguments that communities and litigators can bring. I already alluded to the fact that what this advisory opinion does is it sets out a framework, and there are certain tools that it provides. So, for example, in stating that the obligation for due diligence is a stringent one, it removes discretion. What that specifically means and concretely means, say, for a community that has concerns about the licensing of a fossil fuel project, is you can now expand the scope of your challenge, not just from the procedural aspects, and those tend to be really significant because there continue to be deep challenges with communities to access these processes in meaningful and accessible ways. And a number of decisions from South Africa to Kenya have challenged these licensing decisions on that basis. But you can now also argue that a licensing decision does not conform to your state's obligations in terms of meeting the global climate target, that it's not in consonance with the nationally determined contributions. Again, as I mentioned, this is no longer just a free discretionary area for states. So there are adequacy requirements. So for example, if you're going to license this project, what does it mean for your nationally determined contributions and your contributions towards global climate targets? And that's new ground. In domestic litigation, we've struggled. In Kenya, for example, I can say we've struggled to make climate impact assessments feature as part of these EIA processes. There's been slow but progressive success in doing that. And I think what this advisory opinion does is just provide stronger basis and footing for that. What's likely to be the challenge, I think, is moving the idea, because the tool is definitely there, but it now might be a question of transforming mindsets. And that's both in providing precedents and a tool that litigators can now deploy. And then the other side is in terms of what is the judicial reception to these broad and expanded arguments. And a lot of organizations do judicial training. It's through policy briefs like this, because the judges are also people. They live amongst us. They come across these policy briefs. They read them. And hopefully there's then a transformation so that then there's this new powerful tool that communities and organizations can use to challenge and push for more ambitious and stringent decision making. It's not the big sort of sexy strategic type of litigation, but one of the things I really do appreciate, having done this for some time, is environmental impact assessments are really democratic. In the 7 or so years that I've practiced as a lawyer, I've seen communities and different individuals really find relief that, I have a voice through these processes and I can participate. And if you pull that together with this finding that your state, your country has a binding obligation to show that the decisions it's taking reflect the most ambitious position it could take, I think that's powerful. And then the last point I'll finish on it, I don't think it's just about sort of challenging fossil fuels, but part of that due diligence requirement requires states to also factor in everything that is at their disposal, and that includes alternatives. Again, that's something that one rarely sees in the decision-making matrix for these licensing decisions. There's often quite a lot of influence for investors to push for certain types of investment. So in this decision-making, I think there's also huge adequately account aligned with the ambitious binding obligations African states also have, and also that are better for the environment, for the health of communities. So I think, that would be one direction. I think this will have direct implications, and the advisory opinion does that in a lot of ways. Thank you.
Yeah, thank you so much for that, Mark. And yeah, I think you break it down really well in terms of the different layers and the different impacts it will have. Because sometimes there's also that concern around how some of these decisions are so distant. They may not even be felt, at a community level. They may not be felt, on the continent specifically. And it's, you've really broken it down well in terms of, the different ways it will impact, whether it's in the African courts, whether it's through, NDCs, also just from an institutional point of view, how it is that it could all just translate, which is really refreshing to see something that was decided at international level, having that potential impact, or that it will have that kind of potential impact and possibly benefit, our communities in the long run. Let me bring you in, Dr. Joyce, and come back to the science. And just from, in your introduction, you had mentioned just the experiences you've had, specifically one with the Kenya submission, but also just in the current Africa court submissions that are happening as well. So maybe for us to find out a bit more, I'm not a scientist. Once upon a time, I thought I would be one, but yeah. Just from your experience working as, a climate scientist, and especially, attribution science, how can African governments practically use climate science, particularly attribution science, as mentioned, to translate the ICJ opinion into stronger climate action and accountability?
Yeah, so I think that's a really good question, and it's really the scientific evidence and the grounding that are sort of helped the clarification of concepts like responsibility, due diligence, prevention of harm, understanding issues of, like, for example, intergenerational equity, which can sort of strengthen sort of the legal claims or to push for justice. And I think it's that understanding. So the science is you really need the grounding of the science to enable you understand what is the relationship between emission of greenhouse gases with the impacts or the losses and damages that people are facing, and how this is affecting every community in Africa and also every economy. And so to me, I think even to answer that question first is for us really to understand that Africa's relationship to the climate crisis is really defined by a deep historical and structural injustice. So we know that climate change just didn't happen in isolation, right? We know that it's rooted in centuries of slavery, colonialism, extraction, and basically an equal distribution and accumulation of wealth and power. And we know that what is happening sort of in the modern economies, the modern fossil fuel economies, was built upon these systems that extracted both labor and resources from either colonized people of Africa and territories, or even people who were made to work in plantations or mines to build these colonies and these territories. So that understanding is really important, because if you understand that continuum, so understanding that continuum all the way from slavery to colonial extraction to modern carbon economies, it really explains why for many African economies or scholars or policymakers or activists, climate action is not just about phasing out of fossil fuels, right? So it's about reparative justice, it's about loss and damage, it's about equitable development, it's about transformation of the global economic systems. So, and really you need the science to sort of explain and put all that into context, and make us really understand that for Africa, it's not that we are saying that this one, it's not aid, right? It's not charity or aid. It requires sort of meaningful transformation, like structural transformation, that can actually help Africa sort of address the climate crisis. And to me, I think having science sort of interact with legal strategies and movement building can really reinforce each other sort of to advance the climate justice in the African continent. And we can tap from the science that exists. So all the way from the Intergovernmental Panel on Climate Change, which is the authoritative UN body that provides the latest available science, to the science that is available within the African institution by African scientists that can help articulate these issues to help African states to really understand where is their position and how they can push for this.
Yeah, thank you so much for that, Dr. Joyce. I like how you say how we can, utilize science to communicate, some of the positions, particularly when it comes to African governments. I think a lot of the conversations we tend to have sometimes on the continent is that a lot of the science, we're being told the science. It's coming from external, often led by a lot of the global North organizations. How do we create spaces and platforms for our own African scientists to kind of lead in, developing and pushing some of the nuances around the evidence and so forth? But also, how do we own this conversation, and how do we have these conversations in a way that when we work with communities and we bring communities, or even we have governments pushing certain narratives, there's a sense of ownership. And I think at the heart of that ownership and that evidence is going to be the science. Really, really appreciate, I guess, the work also that you guys do really in building that evidence, because ultimately, I think in a lot of conversations that we have at conferences, there's always this data is missing. There's a data gap. There's not enough information. There's always that. And it's like, how do we then close that gap? And how do we make sure that some of that evidence and conversation and science is really Africa-led, Africa-owned, but also when we push the narratives with the backing of the science, it's actually informed by a lot of the work that then is done by scientists and policymakers from the continent. Let me bring you in here, Abdoulaye, just in terms of, working with communities, particularly those impacted by climate change. And you had mentioned, obviously, Gore Island, but also generally in Senegal. And my question is, how can, African countries use this ICJ opinion to advance claims on climate reparations? Because that's a big thing. And particularly with the African Union having coined reparations as one of their themes, well, for last year, but there's a continuation for the next, I think, 10 years. They're going to be looking at elements of reparations, but also loss and damage, which has been at the core of conversations, particularly within the UNFCCC, but also historical responsibility. So climate reparations, loss and damage, and historical responsibility, and how we can actually use, or African countries can use this ICJ opinion to advance these claims, particularly in the context of affected communities.
Thank you. Do you hear me?
Yes, we can hear you.
Do you hear me? Okay,
Yes.
wonderful, wonderful. Thank you very much for this important question. Dr. Joyce was talking about how in Africa we used to be victims in many from slavery to colonialism, now in climate, etc. But in my view, one of the most powerful contribution of this ICJ advisory is that it gives a legal language to what communities are already experiencing as a concrete injustice. And for many communities, coastal island and in Senegal, in Africa generally, climate change is not an abstract diplomatic issue. It is a coastal erosion, it's a loss of land, it's soil salinization, it is pressure on their livelihood, it is degradation of marine ecosystem, it is the threat to cultural heritage, and sometimes it is the gradual weakening of the bond between community and its territory. In Senegal, this reality is particularly visible in coastal areas such as Saint-Louis, Bani, the Saloum Delta, Gore Island, and many other exposed territories. These communities are not only facing economic losses, they're also facing social, cultural, environmental, and symbolic losses. This is why loss and damage must be understood broadly. It includes loss of income, loss of housing, loss of biodiversity, loss of memory, loss of security, loss of dignity, and loss of future opportunities for younger generations. And from this perspective, African countries and African communities can use the ICJ advisory opinion in three very concrete ways. First, we need to transform community narrative into evidence, and the scientists will help for that. Communities must be supported to document the harm they are experiencing, testimonies, coastal erosion data, maps, economic losses, impact on women, on youth, fishers, farmers, heritage sites, and ecosystems. The objective is not only to say that communities are suffering. The objective is to build a strong legal and scientific files that connect lived harm to identifiable climate-related phenomena with the support of science, law, and local knowledge. Second, the advisory opinion helps bring climate reparation back into the field of law, not only political solidarity. It is no longer only about asking for aid for climate charity. It is about affirming that where international obligations are breached and significant harms is caused, the rules of international responsibility may open the door to form of reparations. And these reparations may include financial compensations, economic restorations, community protection, recognition of harm, guarantee of non-repetition, access to technology, and adaptation finance. And third, the opinion should strengthen Africa's position in international negotiations, especially on climate finance. The loss and damage fund, the technology transfer and adaptation. Africa should use this opinion to argue that climate finance must be predictable, accessible, primarily grant-based, and directed toward the real needs of affected communities. Communities should not be treated merely as final beneficiaries. They must participate in identifying the harm, defining priorities, monitoring finance, and evaluating the effectiveness of reparation. But also, we need to be clear. The ICJ advisory does not automatically solve the issue of evidence, causation, and damage assessment. It creates a framework, but this framework must now be operationalized. This is where African states, local government, lawyers, scientists, and civil societies must work together. We need national and regional mechanisms to document lesson damage. We need community observatories, strong evidence databases, and litigation or non-litigation strategies adapted to African realities. For me, the essential message is this: the ICJ advisory opinion gives affected communities a legal point of reference, but the starting point of any serious climate justice claims must remain the communities themselves, their knowledge, their stories, their evidence, and the right to shape the solution. Thank you.
Thank you so much. That was really powerful. I think one of the key takeaways from that is, how do we move this advisory opinion into something operational? How do we operationalize it? And I think all the layers you've really described give us that anecdote of, how do we include all the evidence building, the data components, the predictable financing, the tech transfer. All these things are very much important. And we need to move away again from that vulnerability framing, from the constant, affiliation and attachments to, yes, our history obviously plays a big part in how our states and how a lot of our systems operate, but how do we also move forward in terms of building systems and operationalizing all of this for the benefit of the continent. I'm going to invite people to really write questions in the chat before I come to Meshack for his question. Please also raise your hand. We want to definitely have a moment to really interact and take any questions that you may have. If you're too shy to talk, please type it in the chat. Also happy to take them in the chats. But I hope so far the webinar has just been very much fruitful in terms of the information that has been provided. Coming to you, Meshack, and yeah, I think it wouldn't be a climate change conversation with Africa if we're not going to speak about fossil fuels, and how an opinion like this may or may not be able to regulate the specific conversation on fossil fuels. I think it's still quite a controversial one on the continent. Some countries are more for, some are not. Some countries are like, we're not emitting that much, so why are we stopping the utilization of fossil fuels? But there's the reality of fossil fuels also do cause, climate change, and the emissions that they actually release are a lot. There's all of that stuff. Is there a place for this specific opinion, even with the Africa Court, case also unfolding, for us to speak about this opinion and how it will impact the conversations we're having on fossil fuels? So, and this is coal, gas, and oil, in terms of the continent and how we hold African governments accountable. They're governments that are fossil fuel dependent economies that are like, we need this fossil fuels. So there's also a big debate around development and the utilization of that versus the obligations to then, to still take on climate action. So I don't know if you'll have an answer, but we have faith in you to give us an answer regarding that.
Thanks, Karabo. It's an interesting, good question. And it is a discussion that, as you say, very, very controversial in Africa, in terms of, right to develop our fossil fuels, and extract and extract resources from them. And on the other side, the push for the phase out and everything. So yeah, I will attempt to link my answer to the ICJ advisory opinion, and the most important aspect of it is the right to not harm the climate system, and might not be as significant for Africa because we historically are not big emitters. We are if anything the least within the the ranks. But the most important question also is the duty of the state is also to exercise due diligence. And due diligence is to say, developing fossil fuels now in 2026 or in the coming years, it's a big risk for any country within the global system. One, the big risk of getting locked in an infrastructure that might not be as useful in coming years is a big, big risk. The second most important one is the countries that have really tried to benefit from fossil fuels, and there are many examples of some that have benefited. It also has its own, as a sector, it has its own challenges, and one of its biggest challenges is just the resource scarce issue with it, in terms of where countries that try to exploit it try to also all the sectors just get poised into that, and it just destroys the economy from a perspective of just the dependency of the various sectors, and just destroys all sectors so that the country becomes very dependable to it. And that issue really must be the volatility of global prices, for fossil fuels, which leaves many of these countries really exposed after huge investments in them. Are there alternatives? Definitely there are. And the advantage of this is we're in a continent that is extremely blessed with renewable energy sources from solar, wind. Kenya, very blessed with geothermal as well. And also, huge resources for hydro within the continent. And the question really must be, if you want to develop or industrialize, do you choose the green industrialization way, where your industrialization is powered by renewable energy, which we have in abundant sources, and now in recent years can be produced at way cheaper levels than fossil fuels? Or do you want to go the old way, where you lock in yourself and your economy to something that has proven to be very destructive to economies? But to link this even better to what the judges said in this area is, each country has to choose its own path according to its own capabilities and according to its own commitments in the nationally determined contributions. So the advantage of this is it's a little bit country-led. The duty exists internationally, but still how you progress towards achieving that duty is country-led. And the advantage now is, in today's world also, finance is also moving towards green and cleaner energy. Investors and developers are also more poised to be attracted to renewables that developments that are renewable based, and also importantly, also national energy plans and strategies are also prioritizing renewable energy, including countries that are historically powered by fossils, like South Africa, which has huge dependence on coal, but it is continuously prioritizing renewable energy, and it has that program where it's trying to phase out coal power projects. And of course, it has to be done within a just energy framework. And so those countries are trying to have these just energy transition frameworks and plans to ensure that the transformation and the transition does not leave communities out that depend on oil, doesn't leave the workers out that depend on the oil, and also the whole ecosystem of the economy that does that, so that you can have repurposing of the plants, number one, to do something that is cleaner, and also try and do something for the livelihoods of the people who depend on these resources as well. But importantly, is the shift is happening to renewables and clean energy, and it's happening everywhere. So the only way that remains, I think, is to go the way that the continentally and globally that the commitments are looking like. Yeah, I'll stop there. Thanks, Karabo.
Thanks, Meshack, and thank you for taking a jab at that one. Definitely, like I said, very controversial one, very tricky one, because there are also layers to it. It's not just the legality, it's also the conflict now. Now we're speaking about fossil fuels in the context of conflict. Dr. Joyce, I did note your hand. Just going to take a question. I have a question from Kimutai, who says, how can the ICJ Advisory Opinion ensure that climate finance is treated as a legal obligation to repair harm to nations? Any takers for that one? So how can the ICJ Advisory Opinion ensure that climate finance is treated as a legal obligation to repair harm rather than just loans that create more debt for vulnerable nations? And we need a quick answer because we'll run out of time. But yes, Dr. Joyce. So I'm going to give it to you, Dr. Joyce, and then please also add what you wanted to originally say, and then also your parting shot.
Thank you. I'll try to be very short, but I think on the question on climate finance, I think it's really so. So remember how I framed the entire climate change issue as an historical and a structural issue for Africa, and it touches on historical responsibility, and it comes with, what does that mean? It means that for countries, so it's very clear within even within the IPCC, the UNFCCC framework, that the countries that are responsible for the crisis will be supporting developing countries that are impacted by the crisis, who are less responsible for it. And in that case, the support was in form of finance, capacity building, and technology transfer. And so it's really well grounded there. And I think it's even well articulated within the ICJ, and it could trickle down to the African. And that's why I said, like, really picking some of those very critical context-specific issues that were articulated in the ICJ, part of the international debate, to frame it on what it means for Africa, for us. And that, I think, that is a very good example of that, because in that case, you'll be talking about financial compensation, for example, for loss and damage. You're talking about debt relief and debt cancellation, for example. What does that mean? You're talking about technology transfer. So it's really looking at that the debate on climate finance must be hinged on historical responsibility, because we know that industrialized countries have accumulated wealth through this fossil fuel driven growth that has contributed disproportionately to global emissions. And we know the crisis, for example, is actually represents, so it's not just, so that what happened from those accumulation of wealth, which has contributed to global emission, is that it's not just caused an environmental problem, it's caused historical imbalance in the global economic system. So basically, we are saying that we're not asking for charity or aid, but we are saying there should be meaningful transfer of financial resources to actually support countries in the global south, or Africa for this matter, to help itself sort of address this crisis. And so that is that would be my answer on that. And I just wanted to, I really enjoyed the intervention that Meshack made on just transition or phase out fossil fuels. What does it mean for Africa? And I really like the way you put the balance of avoiding this lock-in in these technologies that will actually be stranded after some time, and also thinking about what is a fair and just an equitable framework that actually can help countries transition away from fossil fuels. Because to me, what I understand very clearly is that if industrialized countries phase out now, like now, and I mean now, a just and equitable transition should really enable countries like Nigeria and Sudan to move gradually away from and fairly towards decarbonization. And this should really be supported by technology transfer and financing from these countries to enable them meet their basic developmental needs. Because I think it's very unfair to say, for example, to Nigeria now, that you have to close down your refineries tomorrow. And we know that these are the sort of the resources they're using to bring millions of people out of poverty, to help people get access to clean energy, to electricity and all that. So I think there should really be that balance. So I really agree that we should be moving towards green industrialization, and definitely that is where we should be headed. But I think it should happen in a way that they support, and also in a way that avoids economic entrapment, in the sense that we don't want a situation where African countries will now be depending on renewable energy technology or resources from the north, where you have to import solar panels, you have to import whatever technology that you're going to be using to transform, because what that does is it perpetuates this same structure that has been for the longest time have made Africa be dependent on, or like act as like be dependent on technologies or on an economy, or be trapped in a way that it will continually be asking for the resources to be able to fund its own development. So I think, to me, they should be a really, and as you put, I think you put it really well, that they should be a very and that is why it's a very sensitive topic. But I think it should be articulated in a way that it brings all the issues, services all the issues, and balances the issues in a fair manner.
Thank you so much for that powerful parting shot, Dr. Joyce. So I'm going to bring in Mark, Abdoulaye, and Meshack. Just one key thing you would at least like the audience to know that would be quite important for this discussion on, this ICJ opinion, but also just the conversation on climate and where we're moving, or where we hope Africa will be in the next couple of years, or what Africa should prioritize. And yes, I'll start with Mark.
I'll make, I think, a couple of quick points. One thing that's reflected even in the panelists here is the different groups and participants that are needed to move the needle forward. It's the same story of the advisory opinion. Quite outside of the content of the advisory opinion, the journey of how it got to the ICJ is something for the books. It involved different stakeholders. It definitely involved the science, and it's that science that provides grounding. It's the lived realities Dia spoke to, and that's something that I'm really excited to see taken up on the continent at a domestic level, and even with the impending advisory opinion at the African Court. So I think, for me, that's also a great story, because I think that's how we move the needle forward. It's a big problem. It has so many different layers. So it takes all these different actors, but definitely pushing in a very concerted way to make sure that voices on the continent are heard, and that justice is served, because that's, I think, the second important point. These aren't abstract discussions. They translate into lived realities, and those should inform decision-making going forward. Lastly, I think this policy brief is really fantastic. It does a great job in summarizing sort of the key points and things that people can take away, whether you're interested in the climate negotiations, whether you're interested about it from the legal points it brings, and there's a host of other materials out there as well. So I think that we've been given the tools. It's for us to now see how best to translate them into action that's meaningful. Thank you again to PowerShift Africa. Thank you, Karabo, for moderating, and thank you everyone for joining. Thanks.
Thank you so much for that, Mark. And Abdoulaye?
Thank you, Karabo. Just before the final word, jumping back on climate finance, it's important to know that today a large part of climate finance remains too fragmented, too slow, and too difficult to access for communities and local institutions. It often finances projects, but not always the long-term capacity that would allow Africa to own and drive its own transition. For real transformation, we must move from financing isolate projects to financing systems, national capacities, local institutions, scientific data, green industries, youth training, meaningful technology transfer, and African value chains. Climate justice cannot mean that Africa remains dependent on imported technologies, as Dr. Joyce was saying, external consultants and unpredictable finance. It must mean ownership, sovereignty, predictive capacity, and direct benefits for people. And looking ahead 5, 10 years, bold shift African countries must make to become true leaders in climate industrialization that Africa must make is to build a just transition from its own territories and communities, transforming our coastal zones, islands, cities, and rural areas into laboratories of solutions, and making climate justice not only an international slogan, but a measurable public policy properly financed and monitored by citizens. And this policy brief is really lovely as it presents things so simply and make the information accessible. And thank you to Power Shift Africa for that. Congrats to my dear Meshack. And to close, the ICJ Advisory Opinion does not only give African states a legal argument, it gives them a method, document harm, strengthen evidence, project rights, demand reparations, and align all public decisions, including energy decisions, with climate justice. Thank you.
Thank you so much for that. Definitely, it's beyond just the opinion, but it's really a framework and a basis for us to have that discussion, like you said earlier, on how do we operationalize this conversation. Meshack?
Thanks, Karabo, and the other panelists, Mark, Dr. Joyce, and Abdoulaye. It's really been a refreshing moment to discuss and get to have this discussion. My part in short will just be, I think, one point. And it's importantly to say that the advisory opinion shapes in a big way how all projects within the continent are undertaken for African countries. And this includes infrastructure projects to renewable energy projects to industrialization projects, because the era of fragmenting and just doing projects because an investors come or doing things that are very short term is coming to an end, because all projects must somehow fit within the national framework that feeds also into the climate commitments for that country. So this means that projects now are likely to be more focused, more integrated, and we do not have situations where we have power lines passing over people's homes who do not have access to electricity. We do not have agricultural zones that are left out of productive use of electricity, who can use it for cooling and processing of agricultural produce. And this is only going to help Africa from an industrialization perspective. Because we have had systems where, investments lead to stranded assets, and really there's no integration into how the projects are done. The fact that now the advisory opinion says countries must exercise due diligence, countries must also be very careful with how environmental impact assessments are done. It somehow feeds into all that ecosystem of how does a country actually undertake its national strategic plans and strategies in a way that is more integrated than they are doing in the current moment. So hopefully that will lead to a more industrialized continent, more jobs for our people, and more progress for the continent. Thank you. Thank you so much, everyone. It was my time to get here.
Yeah, thank you so much for that, Meshack. I think it's a really great way of closing this off, to say that it's not just about, this decision, influencing how the state obligations or the legalities of this conversation. It's really about the entire system. It's changing how, with its business being done, how governments are going to operate, how governments can actually hold other people accountable, it's really a game changer for the continent, not only from that context of it benefiting us, benefiting communities, but also trying to make sure that we create a system on the continent that benefits the continent. And like I said, it's really, while it's a decision that was made, yes, at the ICJ, we wanted to have a conversation on what does this mean for Africa? What does it mean for our continent? What does it mean for our people? And what does it mean for our resources as well and our development? So it's really, really great to see what this really presents for us as a continent. But thank you so much to the panelists also for the contributions. Really, really impressed with all the contributions. I think we also had a wider scope in terms of discussion, from science to community to law to policy. I think the discussion in itself shows that the decision or the opinion is not just vested within the law, but it's vested within a bigger system just when it comes to the climate conversation, but also holistically our development as a continent. And thank you so much to the audience. We appreciate the question as well. Caroline, we definitely noted the recording will be made available. Please do engage with the policy brief. As mentioned, the link has been shared in the chat. Dr. Joyce shared also very important information saying that the United Nations General Assembly is expected to adopt the ICJ Advisory Opinion. Look out for that as well. We hope this is the beginning of a conversation and not really the ending of a conversation. While we are ending this webinar, we'd really like to thank you so much for spending time with us to really engage. And just, yeah, let's continue having this conversation and pushing at different angles, just the interest of Africa and the conversation, how system change, how we just continue to the speakers once again. Thank you so much, everyone.